Hi, my name is Mark Friend and I'm a director here at Friend & Grant. Over the many years I have been in business, one question that causes more grief than any other is, are my workers self-employed? I'm going to answer this question in two videos. The first identifies the problem and the second, the solution. Most business owners assume that provided the worker gives them an invoice, then everything is fine. A few take a blasé attitude in that they know a worker is in fact employed and simply say, let the taxman find it out. The fact is, if you get it wrong and the taxman considers that your worker should be treated as an employee of your business, then you could be liable for the tax and national insurance due on their earnings for 6 years. With penalties and interest, the sums can be horrific. Maybe you will get away with it, as HMRC are under-resourced. But with the new powerful computer systems such as Connect and huge investments in IT infrastructure, the net is closing. We believe that every business should regularly review their workers to ensure they are genuinely self-employed. All businesses are impacted, but those in construction are particularly at risk, as self-employed labour is standard practice for most construction businesses, and those who engage low-skilled labour on day rates are particularly at risk. What defines a worker as an employee? There are many factors to consider, but the following are the main signs of employment. The worker has been with you for a long period of time. The worker is paid a day rate or hourly rate. The worker is closely supervised. And finally, the worker has no real financial risk. If all these apply, then there is a good chance your worker is actually employed. If this is the case and you're treating them as self-employed, then your company is liable to the additional tax and national insurance due. You're also exposing yourself to a potential claim from the worker for unpaid leave and other employment benefits, as in the Pimlico case. The Pimlico case is worth a closer inspection. Despite the fact that Mr. Smith filed tax returns on the basis that he was self-employed, was VAT registered, was entitled to reject work and was able to take outside work, the Supreme Court held that the Employment Tribunal had been entitled to find that he was an employee. Significant factors in the decision included: Mr. Smith was required to wear a Pimlico branded uniform and to use a Pimlico branded van leased from Pimlico. Mr. Smith also had to carry a Pimlico identity card and closely follow the administrative instructions of its control room. The contract referred to wages, gross misconduct, and dismissal, and included a suite of restrictive covenants concerning Mr. Smith's working activities following termination. Whilst Mr. Smith was able to swap assignments with other plumbers already working for Pimlico, this was more akin to swapping a shift between workers than providing a substitute. Providing a substitute is a key indicator of self-employment, and it is where the self-employed individual has the right to send any suitably qualified person to carry out his work in his place. The Supreme Court's decision enabled Mr. Smith to proceed with claims of disability discrimination, unlawful deduction from wages and holiday pay against Pimlico. So, are your subcontractors affected? Hopefully what I've said has got you thinking that maybe things are not as straightforward as you thought. In my next video, I will look at the solution. The employment status of a worker is one which every business owner needs to consider, so if there are any uncertainties, please seek professional advice.